What will happen at your first court appearance when you've been charged with a DUI in Ontario? That's what I'm going to cover in this video. I'm Dan Joffe, DUI lawyer at Nextlaw. Let's get started. When you get charged with a DUI in Ontario, the police will give you paperwork, including information regarding your first court date. Here's what you need to know about your first court date for your DUI in Ontario. 1, it's not a trial date. Your first court date for your DUI is called a first appearance. This first appearance covers any drinking and driving charge in Ontario, including over 80, impaired driving, and refusal to take a breath test. Your first court appearance is not a trial, and the police that charged you do not need to be there. It's simply the first time your DUI case will be heard in an Ontario court, which is why it's called a first appearance. At this court date, 3 things will happen. First, you will enter a plea, either guilty or not guilty. Second, you will get documents which are called disclosure. This is the evidence that the Crown lawyers will be using to convict you of your DUI. And third, a future court date will be set for your DUI case. 2, you or your lawyer must attend. Your first court date is mandatory. You can appear, or you can have your lawyer appear on your behalf, but attendance is not optional. If you don't appear, the police will issue a warrant for your arrest. The police will arrest you and charge you with a new criminal charge known as fail to appear. You would be held for a bail hearing and maybe held in custody until your trial date. Bottom line, you or your lawyer must attend your first court appearance date. 3, evidence won't be complete. In Canada, the Crown lawyers are legally obligated to disclose the evidence that you'll be using to convict you of your DUI. So when you go to your first appearance court date, you will get a disclosure package. What most people don't know is that this disclosure that they give you will likely not be complete. The police will give you what they have, not necessarily what you need to win your case. In other words, you will only have some of what you need after your first court date. A complete evidence package is essential to properly fight your DUI charge. So you will most likely need to ask the Crown for additional evidence. Finally, if you've been charged with drunk driving, DUI, impaired driving, or refusal to take a breathalyzer test, your legal strategy can make the difference between winning and losing. Reach out, let's have a confidential discussion about your case. The call is free and you can book a time by clicking on the link in the description below.